I was looking back over our previous podcasts and realized we'd never touched on this, despite this being something that is top of mind for now over 2 years. This is a really interesting case that the SEC is bringing on a novel theory of insider trading, and it is going to trial next week. That's why I was jumped to mind as something to talk about on today's podcast. But it's been percolating in the Northern District of California for since August 2021 is when the SEC filed this. And the thing that's interesting about this, and the reason this is a novel theory, is that the gist of what happened here is a guy named Matthew Panuwat who works for a sort of smaller biopharmaceutical company called Medivation. And he learns in the course of his employment that Medivation is in talks to be bought out by Pfizer. And with that information, which granted would have been probably material non-public information, he should not trade in his own stock about that. That's a pretty standard classical insider trading theory. You are an insider. You cannot trade when you learn things about what will change the value of your own stock of the company you work for. But Matthew is savvy, and what he does is he trades in Insight, and Insight is a similar company to Medivation. So it's seen as a peer-ish company in this sort of smaller space of, like I said, biopharmaceutical research and development type companies. And so he ends up making about 100, I think $107,000, something like that, because he puts two and two together and thinks, hey, if Pfizer's about to buy us, Insight is very similarly situated, either because of just the news of Pfizer buying us or the fact that there might be a suitor for Insight, whatever his reasons are, he buys in a different company. And like I said, that ends up earning him a significant windfall. It's 100 some $1,000. So, as you can imagine, just by those facts, this is a really fascinating case because he has no information at all about Insight. He only knows information about his own company. And so everyone is a little bit baffled how the SEC is going after this guy for doing this thing. But the SEC's theory is, hey, listen, you got MNPI, which is material non public information. You breached a duty, and the duty he breached was that he had signed an employment agreement that said he would not trade based on any information he receives in his employment in any company. It doesn't even say in peer companies or anything. It has a really blanket, broad statement in the employment manual about how he's not supposed to trade in anything based on information he learns from his firm. And so the breach of duty the SEC is claiming here in order to bring what's a theory, a case under the misappropriation theory. You've breached some sort of duty and you've made money in the trade and as a result of that breach of duty. That theory already is about 30 years old. That came about in the O'Hagan case in the mid 90s. And so it was a new thing. We used to only have this classical understanding of insider trading, which is you as the insider in a company should not be trading based on information. So it's an insider idea of just that's what you cannot trade in. This appropriation theory expanded that to a broader sort of idea of something about another company and in breach of the source of the information, a duty to that source of information, that is sufficient to find insider trading liability. This is that tweaked a tiny bit. So there is potentially this breach. The tweak here is that the information he learns isn't anything to do with this other company. He's really the novel idea about this case is that sort of almost analysis, the sort of additional step that he is trading a different company without any necessarily information about that other company. And the SEC's theory is that these companies are economically linked in such a significant way that is sufficient to basically have been inside information effectively almost in Insight. So this is, like I said, the first time the SEC is moving forward with this idea of shadow trading, meaning I know about this, and then the shadows, the Insight being the shadow company that's going to follow the information about Medivation. That is what is the problem here. And so last January 2022, the SEC won the denial of the motion to dismiss. Panuwat moved to dismiss, saying this is not actually illegal. I'm putting maybe some analysis together or not. I'm just trading an insight. That happens in January, and then just in this past November, late November, the court denied his motion for summary judgment as well. So we are going to trial next week. And so it's interesting. And even just this denial of summary judgment had some really important holdings, meaning that, of course, this was material information. Panuwat argued that it wasn't non-public, that this wasn't yet an acquisition that had been finalized, and that maybe the fact that they were in talks wasn't necessarily completely private information. But the big one was about whether or not this is a breach of duty. I do think the SEC has a slam dunk on this idea that he had signed an insider trading policy that said he wouldn't trade in any other publicly traded company. That's a pretty big problem. But the court went further and said there's a couple other duties here that were sufficient to find a breach. And one was just a general confidential information for anything regarding your business and your employment at Medivation. That should have been considered confidential. But then finally, the one that I think is going to get the most traction is the SEC argued that he has just a general duty through this sort of idea of agency principles, just idea that you should not have used anything for is basically what the gist of shadow trading, I think allegations will turn on going forward, even in the absence of some of these employment policy is not to trade. And that's really, I think, what's going to be the importance of this case. The fact that there's an employment agreement saying you cannot trade, right there, you have a violation of an employment agreement. So that's in itself maybe enough to show a breach of duty. But imagine if there had not been that employment agreement. That's the angle I think that's going to be novel and that the SEC is going to try to keep pushing on to say, no, just in general, you cannot do shadow trading because you're putting two and two together about things that could affect another company. And so you could imagine the slippery slope of this is could seem a little drastic to those who are analysts or people in this space that are like, I thought that was actually completely kosher up until now. And then you have the other side of it, which is no, this is open shut. Someone is using inside information for their own gain. You could have a more ideologue who thinks this is just should be illegal. And this is fine for the SEC to take this, even if it's, again, maybe pushing the current theory of insider trading a step further. That's something we're okay with. That's what I'm focusing on. And I think we should all be looking at next week because it could really alter the landscape for insider trading liability going forward.
Karen, it seems to me that last prong, creating a agency relationship, is moving very close to a blanket honest services or the entire company workforce. Am I hearing that right, or am I just too tied into my Enron thinking?
No, you're not wrong. I imagine you and Skilling have had some beers over this concept of value services, but I think that's why I think I was like, this could be a pretty broad sweep. I will say, speaking of Enron and honest services, this is moving forward under a 10b-5. So the SEC is probably pushing this one. The DOJ in a criminal context could bring this in the same manner, but they also could use securities fraud, which is 18 USC 1348, which is the same concept of insider trading. And that's just any intent to deceive related to a trade in the security. So that obviously the distinction there is you have the SEC on one hand who's moving in a civil fashion versus DOJ in a criminal fashion. That's a pretty significant difference. But there are avenues to get to that place anyway, I guess is what you're saying. But yeah, I think this idea that this agency duty writ large, even in the absence of a signed agreement not to trade, just that you should not be using anything you learn in your capacity in employment to trade in other companies that are not necessarily that's not what the information is about is, I think, is a stretch.
How I read several client alerts on this, and one of the commentaries was, how do you train based on this? Do you tell your employees, sorry, you can't trade in like-minded industries anymore? How far? And then how do you regulate that? Are employees required to self-report purchases of stock in a public company?
It's interesting. I know there's a lot of commentary out there about what sweatshirt I'm wearing. But what's funny is I presented a paper at Michigan State Law Review, which is why they gave me the sweatshirt, about exactly this. And my thought was we expand maybe 10b5-1 plans to cover more of an industry-wide prohibition or have different types of options of when or windows when you can trade based on what apparently also is going to be swept in for being considered insider trading based on information within your firm. Meaning, If I can only trade in Medivation because I'm a Medivation employee based on my 10b5-1 plan, then what should be added to that 10b5-1 plan is anything else the SEC is going to come after me for that's considered using that information as well. So insight should be only trades and insights should be also be done pursuant to a 10b5-1 plan, even though I don't work in insight. So something like that was a thought I had of just maybe everything is completely off the table in terms of what you're trading on. If you think there is any use of this inside information in the other trades.
Mr. Marks, you have a question or comment?
I guess my comment is it goes material inside information. Who else would have that information other than him? So Matt and I were having sort of a background conversation. I think I'm on the side of the SEC with this one. So I'm not speaking for Matt at all. I would never do that. But it just appears to me that it just, I think fundamental logic would tell you that it's just not right.
That's fair. I don't disagree with that, but the only but on that is that there's a lot of insider trading law that is, I think, maybe fundamentally not right, but still is legal for various reasons. Like the law around insider trading is bananas. And so I think we could probably maybe a lot of us agree that, yeah, we should probably tamp this down. But
Mm.
but so far this is something that might have been considered